If you already have a pending adjustment of status case, this new USCIS memorandum could change how your application is reviewed. For some people, the only alternative being discussed is going abroad for consular processing, which can mean more cost, more delay, and in some cases, re-entry problems. That is why this policy matters now, especially for people who filed under the old rules and expected those rules to stay in place. This video explains what changed, who may be affected, and why legal challenges are expected. This is general information only, not legal advice for a specific case. If you want updates like this, subscribe to this channel for more immigration news. To understand the change, it helps to start with how adjustment of status has traditionally worked. For people who are already in the United States and want lawful permanent resident status, there are basically two paths. First, you need a qualifying sponsor or another legal basis to apply. That could be a family member, an employer, or another category recognized by law, such as asylum, refugee status, or the diversity visa process. From there, the case usually follows one of two tracks. You either complete the process abroad through a U.S. embassy or consulate, which is called consular processing, or you apply inside the United States through USCIS, sometimes with an interview at a local field office. That inside-the-country route is what people mean by adjustment of status. The key point is that Congress created the adjustment of status process. It was designed so that certain non-immigrants already in the United States could apply for permanent residence without leaving first. USCIS is now saying that this is an extraordinary form of relief and that it wants to make the process much harder. The agency says it has found a new interpretation of the Immigration and Nationality Act, even though hundreds of thousands of people have adjusted status every year for decades under the long-standing framework. Under this new approach, many applicants who could have filed here may now be told to return abroad and use consular processing instead. That matters because the overseas route is usually slower, more expensive, and far less predictable. It also matters because decisions made by consular officials are very difficult to challenge, based on long-standing Supreme Court precedent. This is one more example of a broader shift in immigration policy that affects legal immigration, not just border enforcement. For a long time, many people assumed the debate was only about unauthorized entry. But the reality has always been broader than that. Policies can be rewritten in ways that make it harder for people to obtain lawful status, even when the statute appears to allow it. That is what makes this memorandum so significant. It does not just affect people at the border, it affects people who followed the rules, entered lawfully, and are trying to use the process Congress created for them. The memo is not just a technical update. It changes the way the government is likely to judge a very large number of pending and future cases. The memorandum, PM 6020199, reframes adjustment of status as what it calls extraordinary relief and administrative grace. In plain English, that means the agency is treating this less like a path people can use if they qualify, and more like a discretionary favor the government may choose to grant. The memo makes two major moves that change the landscape. First, even if you have no criminal history, no immigration violations, and nothing negative in your record, that still may not be enough. You now have to affirmatively show that your case is special. You have to prove unusual or outstanding equities, and you have to present much more than applicants were typically required to show before. The memo does not clearly define what counts as an outstanding equity, or why one case would be unusually worthy of approval over another. The second major change is especially important for people already inside the United States. USCIS is saying that if you stayed here and used the adjustment process instead of leaving to do consular processing, that decision itself can be treated as a negative factor. In other words, using the exact pathway Congress provided for people already in the country may now be counted against you. That is a serious shift in how cases are evaluated. It effectively penalizes people for trying to use the system that was built for them. For many applicants, especially those who have spent years building lawful lives here, that is a major departure from the way the process has worked for a very long time. The size of the impact is enormous. Right now, There are about 1.24 million people with adjustment of status applications pending at USCIS. Every single one of those cases may now be reviewed under this new standard, instead of the one that existed when the application was filed. Looking forward, roughly 700,000 to 800,000 new adjustment applications are filed every year. On top of that, there are millions more people who already have approved petitions, but are waiting for a visa number to become available before they can even submit the adjustment application. Many of those applicants are workers from India and China who have been waiting for years, and in some cases for decades, because of the backlog. We are also talking about people who have lived here lawfully for a long time. Workers on H-1B visas, spouses of U.S. citizens, children of U.S. citizens, and people who entered through humanitarian parole from Cuba, Haiti, Venezuela, Afghanistan, Ukraine, and other countries. There is also a very real issue for people from the 39 countries affected by current travel restrictions. If you are from one of those countries, and you have been trying to adjust status in the United States, this memorandum suggests that you may be pushed toward processing abroad instead. But for many people in that group, going abroad is not a realistic option. The travel restrictions can make it impossible to come back, and immigrant visa issuance may be blocked or severely limited. So the memo creates a contradiction. It tells some applicants to leave, even though leaving may prevent them from returning. That is why this policy creates such a serious problem for people inside the United States from those countries, and why it could affect many others as well. Leaving the United States for consular processing is expensive on its own. It can also create serious immigration consequences if your status has ever lapsed. For some applicants, departing after a period without lawful status can trigger a 3-year or 10-year bar to re-entry. That means a person who leaves to follow the new approach may not be able to come back for years. In practical terms, USCIS is presenting many applicants with a choice that is either legally unavailable or personally devastating. That is especially true for people who already built their lives here, who have family here, or who have spent years waiting because the system is backlogged and slow. Now let's talk about whether this memorandum is lawful. There are some serious problems. After reviewing the policy closely, there are several strong arguments for why it may not survive legal challenge. The first issue is procedural. When a federal agency wants to change a major substantive standard, it is generally required to go through notice and comment. That means the agency has to publish the proposed change, invite public input, review the comments, and then finalize the rule. USCIS did not do that here. Instead, it issued a memorandum that appears to function like a rule without following the rulemaking process. Courts have struck down agency guidance before when it tries to act like a rule without the required procedure. That same issue has already come up in litigation in Massachusetts, where a judge indicated that the agency was likely on weak ground because it had not provided the public with an opportunity to comment. The second problem is retroactivity. More than 1 million people filed their cases under the old standard. They paid filing fees, gathered evidence, prepared supporting documents, and built their applications based on the rules in place at the time. Now, USCIS has changed the standard in the middle of the process, without warning and without acknowledging the disruption that creates. That raises obvious fairness concerns. People should not have the rules changed on them after they have already filed, especially when the change affects the outcome of cases that were submitted in reliance on the prior framework. The third issue is the Supreme Court's decision in Loper-Bright. That case changed the way courts approach agency interpretations of statutes. Under the older system, agencies often received more deference from the courts when they interpreted ambiguous laws. Loper-Bright reduced that deference and made clear that federal courts have the power to interpret the statute themselves. That matters here because USCIS is relying on older cases from the pre-Loper-Bright era to support the idea that adjustment of status is rare, extraordinary, and only appropriate in extreme situations. Courts now have more room to read the actual text of the law for themselves, and the statute does not say what USCIS is now claiming. Congress did not use the phrase extraordinary relief. USCIS added that concept on May 21, 2026, even though the Immigration and Nationality Act has not changed for roughly 40 years. So, what happens next? Legal challenges are coming. The strongest claims will likely focus on the failure to provide notice and comment, the harm to applicants who relied on the earlier standard, and the practical impossibility of the memo for people from the travel restriction countries who do not have a realistic consular processing option. We expect one or more lawsuits to be filed in federal court, and this policy looks highly vulnerable to challenge. Organizations and individuals across the country are likely to bring cases. This is a major issue for anyone who has a pending Form I-485, and it is also important for people who have not filed yet, but were planning to do so soon. If you already have a pending Form I-485, do not panic, and do not make sudden changes without first understanding how this may affect your case. Keep following the process you already started, and stay in touch with a qualified immigration professional if you have one. If you have not filed yet, you should carefully reevaluate your strategy, especially if you entered on ESTA, visa waiver, or another pathway that you were planning to use for adjustment. It is not yet clear whether people who have not filed will receive the same protection as those who submitted before May 21, 2026. That will depend on what the courts decide and how the legal challenges develop. For now, the most important thing is to understand that this memorandum is not the end of the story. It is an agency policy, not a change to the statute itself. The legal arguments against it are serious, and the practical effects could be significant if the policy is allowed to stand. If this issue affects you, stay alert to official updates, review your filing strategy carefully, and get case-specific legal advice before making any travel or filing decision. Please subscribe to this channel for more updates.